Kia ora koutou, my name's Eve Kennedy. I'm the manager of the Capability and Guidance team here at the Office of the Privacy Commissioner, and it is my absolute privilege to introduce these two formidable women in this webinar with me, who are here to talk about privacy for charities and not-for-profits, tips and tricks. So to introduce them, Louisa Joblin specialises in data protection and privacy law, advising clients on all their privacy concerns. She's a privacy specialist who focuses on privacy protection and compliance, advising clients about the requirements of the Privacy Act, privacy documentation and procedure, and how to respond to actual and suspected privacy breaches. Lou is regularly engaged to advise clients facing a data incident or privacy breach and has experience acting both for individuals and for agencies who may not have met their privacy protection obligations. Lou also specialises in not-for-profit law, so the perfect mix of topics here today. As a not-for-profit specialist, she works with a wide variety of not-for-profit organisations, advising about modernisation, restructuring, governance, voting procedures, and complex member rights disputes. So just a few areas there. Jo Cribb is an experienced consultant and governance expert who has led a variety of projects and assignments. She's regularly asked to facilitate strategy sessions with boards, coach emerging leaders, and lead substantial policy, strategy, and gender projects. Jo was the previous Chief Executive of the Ministry for Women, formerly the Deputy Children's Commissioner and leader of the Commissioner's Expert Advisory Group on Solutions to Child Poverty. Jo is also a director on a number of government and NGO boards, including the New Zealand Media Council and Royal New Zealand Navy Leadership Board. So to get us started, I'm first going to ask Lou and Jo. The theme for Privacy Week this year is debunking privacy myths. What's one privacy myth that you're hoping to debunk in today's session? We'll go to you first, Lou.
Thanks, Eve, and kia ora koutou, very nice to be here this morning. I think that the myth I'd quite like to debunk today is that privacy is too hard for not-for-profits, and so there is no point in doing it at all.
Lovely. And Jo?
Oh, kia ora, and thanks for this creating this amazing space, Eve. I think the myth I'd like to debunk is that privacy doesn't matter. Like, it's an issue for like big organizations with fancy systems, and if we're doing amazing work around our committee for our local sports club, or you know, running an art gallery or an after-school program, privacy isn't really for us. It isn't something we have to worry about, and actually it is. So, and I'm sure that will unfold over the course of the next hour.
Lovely, thank you. Yes, so first off, I guess just a couple of housekeeping matters. This webinar is being recorded. You will be able to get the slides. They should be available on our website later today. You can also check our OPC's YouTube channel for all the previous webinars, so go there. We'll have a chance for questions at the end, so pop your questions in the question and answer box that you've got, and we'll get to them at the end. The other comment I'd make first is just that this webinar is targeting those involved in leading or otherwise engaged in charities and community organisations who might not have a huge amount of privacy resource. So we're going to do some fairly Privacy 101 kind of high-level advice as well, interspersed with some war stories, some examples, and some real-life practical tips from Lou and Jo. So if you're already a privacy expert, this might not be the webinar for you, and I won't be offended if I see the numbers drop off as everyone realises I'm going to talk about the information privacy principles. But that's all right. We're going to wrap up as well with 8 questions or some tips and tricks for those involved in governance of charity and community organisations, practical steps that they can take to get started for managing privacy when they don't know where to start. So that is the plan. I guess for the debunking, the myth I'm hoping to debunk today is to show why it can feel, I guess, for charity and community organisations really hard to know where to start with privacy, and feel too scary and expensive to even start to lift the lid. So I'm hoping to show that with a a bit of planning and proactivity. It doesn't need to be that challenging, and it also doesn't need to be that expensive either for agencies that are resource constrained. Cool. All right. So let's kick off then about what is privacy and why does it matter? So the Privacy Act, which the Office of the Privacy Commissioner enforces, is all about personal information. That's the kind of privacy that we're talking about. Personal information is very broadly defined. You don't need to have a name attached. Lots of people think it has to be really specifically identifiable information, that I can look at a piece of information and say, yes, that's about Eve Kennedy, there it is. That's not necessarily true. So a good test to ask is, could someone, even if it's not me myself, identify an individual based on the information that I hold? And when I was a junior privacy officer back in my youth, I used to go, can I look at this and tell that it relates to someone, even if I don't know who that person is? So that's the kind of scene setting for what personal information is in terms of the Privacy Act. The other point I'd like to make is just that privacy is more than just about legal compliance. So it really goes to trust and confidence. Preventing things from going wrong and responding quickly when they do is really critical to keeping trust and confidence in the communities that you serve, which is really, really particularly important for community organisations and charities, right? So I'd like to throw now to Jo and Lou to talk a little bit about why they think privacy is important for charities and community organisations. So Jo, do you want to kick us off?
Yeah, great. And it's a great summary, Eve. I just think when we often don't think about it, that we are in, of those of us who particularly serve on the boards of community organisations or who work in community organisations, that we often know an awful lot about the people that we serve, and we're often given quite a lot of information, and we often store a lot of that information, and we probably don't think twice about it. It's just about us doing our job. But when you think about, perhaps we know about if we are providing a service, or even if things like sports clubs, you know an awful lot about children's health, you know an awful lot about their family circumstances. When we are looking for donors, we know an awful lot about who gave us money and what our strategy has to be engaged with us. We know a lot of sense of information. And I think we should think about ourselves as kaitiaki of that. We've been given this information, or we've created this information, and we need to look after it well. And I think that's a positive, right? That we trust and respect the information we've been given from those that we serve or interact with. But also just think about the risk if some of that gets out, if we accidentally email our donor file to somebody, or a file about somebody's health in our community, and just think about what that would do perhaps and the harm it could create. And we probably haven't, I don't think we've often haven't thought this through. We're just out there doing an amazing job serving our communities, but we do have all this amazing taonga, all this knowledge, and we need to really look after it and protect it.
Awesome. Thank you, Jo. What about you, Lou? Why should privacy matter to charities?
Yeah, well, I mean, I completely support what Jo said, and I think that the thing that often gets overlooked, privacy is about legal compliance, and you know, we will talk about a bit more about notifying breaches and things like that. But probably the biggest risk for not-for-profits is the reputational risk. A lot of times, the work that you're doing in the community and the trust and confidence that your communities have in you is very much tied up in reputation, and a privacy breach or a privacy incident is something that can really damage that reputation, potentially in a way that's quite difficult to salvage.
Yeah, absolutely. Lovely. Thank you both. I'm not going to spend long on this slide. This is just to make the point that the Privacy Act definitely does apply to charities and not-for-profits and community groups. So it applies to a very, very broad definition of agency. For example, I could actually set up a charity myself with, you know, me or a very small number of people involved, and provided it's me acting in my capacity as, say, a chair of a board of a charity or whatever it is, I'm automatically captured by the Privacy Act. So definitely applies, just debunking that myth there. Oh, I've skipped to the end of my slides. That's not great. There we go. Lovely. So For this slide, I'd just like to note, especially for those who are familiar with the Privacy Act already, that I'm basically trying to cover the entire regulatory regime of the Privacy Act in one slide here. So apologies for the information overload, but I just want to provide, I guess, a bit of the general idea and the scene behind the information privacy principles for those who really have not interacted with it before and don't think about it when they're serving on the boards or of charities and community groups, or don't think about it in their day-to-day work managing charities. So the Privacy Act governs how organisations and businesses can collect, store, use and share personal information. So I describe this as governing the life cycle of personal information. So you've got to make sure that there's a good reason for collecting personal information before you collect it. And then you've got to tell people about it, what you're going to do with it. Once you've got it, you've got to keep it secure, and we'll probably touch on that a little bit more detail soon as well. We've got to give it to people if they ask for it, or correct it. And I think that's something people who don't get a lot of Privacy Act complaints or who aren't covered by the Official Information Act often forget, that actually when they're recording information about their donors or their funders, those people have the right to ask for the information that charities hold about them if they want it as well. You shouldn't be keeping personal information forever. Some of the recent high-profile privacy breaches that we've seen have been because people have kept way more personal information than they needed. Finally, you should only use it and disclose it for the purpose it was collected, unless another exception applies. So, for example, the individual consents to you sharing it or using it for another purpose. For all of these privacy principles, our website has a whole bunch of fact sheets and huge amounts of information that talk through how to apply each of them in practice. So if there's one that really piques your interest or you're starting from nowhere, our website is a really good place to go to get some more info. All right, so Lou and Joe, now turning back to you guys, what do you think it is that commonly trips people up when it comes to privacy for charities and not-for-profits? And shall we start with you, Lou?
Yeah, there's a few things. I think there's maybe three things that I see that most commonly trip not-for-profits up. The first one is around the use of databases. So as Joe mentioned, a lot of times a really large amount of information held in there, a lot of personal information, including quite sensitive, and no real policy around retention in terms of how long that information is kept. So quite often see that databases are used full of information and not very well secured, and maybe lots of people having access to them as well, which can be an issue from the perspective of the accuracy of what is in those databases. The second thing I often see is not having a process in place to deal with access and correction requests. So as you mentioned, especially where a not-for-profit's not subject to the Official Information Act, so they're not dealing with information requests very often. It's a really, really easy way to fail to comply with the Privacy Act, to not have a good process of responding within the 20 working day timeframe. So quite often we're dealing with people who haven't met that 20 working day timeframe, and it's sent them off down a process of complaint and into the OPC. And the third thing is using one device or one login, just really sort of limited security practices, which are so straightforward to remedy, but also so easy to get wrong.
Lovely. That's a great one. Thank you, Lou. What about you, Joe?
I think Lou's covered the main thing. We often have we often have very small organisations with one or two, or we actually have a whole lot of volunteers. We don't necessarily have the most complex computer systems. It's often a Google Doc somewhere, if that, an Excel spreadsheet, and we probably are very focused on serving and doing a great job, and not necessarily then thinking about what information we're gathering through this privacy lens. So I think Lou covered all those options really well.
Awesome. Thank you. All right, so now we're going to touch on privacy breaches. I'll note that the compliance and enforcement team at OPC did a webinar yesterday on privacy breaches, which steps through the process for notifying us and notifying individuals in loads more detail. So if that's something that you want more detail on, you can go to our YouTube channel and watch yesterday's webinar. But just to cover it off, I guess we know that people are going to make mistakes when handling information or setting up systems to handle information. And if you've got a big data set of information, which, you know, some even small charities hold huge amounts of personal information, it can also be a target for hackers. You might not be a massively important, or you might not think of yourself as a massively huge organization that's likely to be a target, I should say. But I think as we move through in this digital era, we're seeing more and more agencies who would never have thought that they would have been phished or hacked. It's happening to them as well. So from an OPC perspective, the best approach is to be prepared, just like you would be for a business disruption, an earthquake, a health and safety hazard. Having the attitude of it won't happen to us won't help you in the long run and won't help you be prepared. A privacy breach will happen is probably the approach we'd suggest you take. And you should make a plan and test it, because a plan is good in theory, but it's got to be efficient in application. And a plan doesn't necessarily mean it needs to be a massive, 15-page document with 72 different contractors involved. For small community organisations, then you might have your general manager or your director doing lots of the steps, right, and managing it largely themselves. But having a plan in place is really critical. I'd also just note that we have some draft guidance on breach management coming out later this month as well. You can see the email address up there on the slide, and we're hoping that that will be useful for organisations of all sizes. So we'd be really keen to hear from charities and other community groups to see if it's useful for them as well. So that's probably all I'll say in terms of privacy breaches. I'd also just stress, I guess, the importance of trying to respond quickly. So there's a legal requirement to notify the Privacy Commissioner as soon as practicable, and from our perspective, that's ideally within 72 hours of the breach being identified, and that way we can help you in your response. So particularly if this is the first time it's happened to you, and you're really needing support, the sooner you can let us know, the better. If you're not sure if the breach is notifiable and that you're not sure if it's likely to cause serious harm to an individual, you should still tell us anyway. So the Act provides for incremental notification. And if you then continue your investigations and you find out that the breach wasn't actually serious, you can let us know and we can downgrade it as well within our systems. So I'm going to turn to you now, Lou, and I hope you might have some war stories to share of some privacy breaches where things have gone wrong and some lessons from those.
Yeah, absolutely. So the thing that I see the most, particularly with not-for-profits, but actually probably with all agencies, is that human error is the biggest cause of privacy breaches. And I think the OPC statistics will support that as well. And that's the thing about it, it is inevitably going to happen. It's just by virtue of the work that we do and the amount of information we hold, and sometimes the speed we're working at or the pressure we're under. So what we see very often is things around emails, blind copy function not working correctly. So meaning to put a whole lot of addresses in the blind copy box, but using the copy section instead. And what's interesting there is that it may just be someone's email address. So you might not think inherently that's particularly sensitive to them, but a lot can be gathered from the context of the email that you see that email address used with. So blind copy failures are a really kind of low-hanging fruit in a way, and also incorrect recipients. So things like Outlook being really helpful in suggesting person X, but you actually mean person Y, and not taking that extra moment to double check. The other thing that we see quite often is redacted documents. So yes, in a law firm, obviously that's in a court context as well, but sometimes for organisations that are dealing with requests for information, so you might have people who are receiving care through your not-for-profit services, or you might have young people that you look after. There may be scenarios in which you do need to prepare documents that have got parts blacked out. Maybe you're responding to an access request. And what we see sometimes is that with the best of intentions, documents are redacted, but then the version with or without the redactions is sent in the wrong place. So it's those human error type of issues that take a split second to do and then can have quite substantial consequences. And the other one that is quite interesting that I've come across, and I like to sort of trot this war story out, is around shared hardware. So it came about during COVID times when everyone was working from home, but I think could still be relevant. Two housemates working on their laptops in their homes during lockdown, and then putting their laptops back in their laptop bags. One of them putting some files in there too, and then the other housemate taking that back to their workplace where the laptop went into a shared laptop cupboard. And then some weeks later, someone took that laptop out to use and discovered a whole lot of other files that had nothing to do with that workplace at all. They were of housemate A, but they'd gone with housemate B. So there's just a really good example of the need for real caution with taking documents home, working from home, carrying client files, customer information, donor funds, that sort of thing. But yeah, all of those war stories really relate to human error.
Awesome. Thank you, Lou. Jo, anything to add from you, or any reflections from your kind of time on the ground in terms of the challenges that charities and not-for-profits face?
Yes, absolutely. And I'll be really interested in your, as a panelist, I shouldn't really been asking questions, but I am going to. Eve's sitting there going, what is she doing? I do think there's a really interesting piece where sharing information can actually save people's lives and mean they have a better, I guess, frame. And I know particularly in a lot of our social services, but also the fear of doing it wrong, perhaps. So Eve, I'm sure we've got lots of people on the thing who sit in that world where actually, if another agency knew this bit of paper, bit of information, that better services or lives could be saved, or things could be, or harm could be minimised. How do you work through that kind of chilling too around? Well, how do I manage my privacy responsibilities?
Yeah, sure. So I think that one answer, probably a couple of things, and Lou, feel free to add to this as well. So the Privacy Act principles are inherently fairly flexible and anticipate sharing to prevent or lessen a serious threat to an individual or to public health. So, for example, that exception in the privacy principles anticipates sharing where there is a really live threat to someone, and in considering what serious threat means, we've got guidance on our website, but you'd be thinking about the imminence of the threat, the seriousness of the threat, all those kinds of things. So there is an express exception in Principle 11, which is the disclosure principle that provides for sharing of that nature. The other point I'd note is that the Privacy Act can be there's other legislation that's obviously in play in particular sectors, and that legislation will override the Privacy Act generally to the extent they're inconsistent. So some really good examples in the social services settings. The Oranga Tamariki Act, Section 66C, provides for fairly broad sharing for child welfare and protection. The Family Violence Act, Section 20, provides for fairly broad sharing for family harm prevention purposes as well. And then there's obviously also production orders in terms of releasing information to police. The Privacy Act clearly does not get in the way of that. So there's definitely lots of avenues, and I recognise that actually for some agencies having lots of different avenues to share information can almost make it harder, and that you have to figure out which is the right one in the circumstances, particularly for social agencies that are providing those kinds of services to families and young people. There's some really good guidance from the Ministry of Justice and from Oranga Tamariki on their different information sharing regimes as well. That's quite a long answer, but I'll throw to you, Lou, if you've got other things I've inevitably forgotten.
No, I don't think I have anything to add to that one, actually.
Lovely. All right. So if we continue along to preventing privacy breaches, so Lou's actually covered off a few of the points I was going to make already. And I think the really critical thing is that there are some actually quite practical steps that you can take to minimise your risk that don't necessarily mean you have to procure an entirely new IT system, which is obviously something that's out of reach for a lot of resource-constrained agencies. So just having good procedures in place, like Lou mentioned, in terms of double checking email addresses, processes for using BCC versus CC fields, and even just providing some training and support to staff to make them feel confident in the choices that they're making and the policies that they've got. Staff training is obviously a really critical one, and I know that's something that can be expensive. And not to just continually plug our website, but that is definitely what I'm doing. But we offer e-learning modules for free, available on our website, and there's something that you can pick up and get your staff to use. And we have different modules depending on the level of privacy awareness that you already have and the different sectors that you're working in as well. The employee browsing issue is something that I'll just touch on, because it's something that we see agencies often don't even think about as being a privacy issue. They might see it as being an HR issue, someone looking at information that they shouldn't have, but they don't also see it as being a privacy breach. It's also something that can be quite challenging to deal with if you are, say, an organisation that only has one laptop, as Joe was alluding to before, to manage that. So just having a process in place for thinking about how you're going to make sure that staff are only looking at what they should be, and the same applies to volunteers as well, right? So particularly in a devolved situation where you've got potentially volunteers working throughout the country, how do you make sure that they know what they should be doing and what's kosher and what's not? All right, it's probably enough on preventing privacy breaches. So there's also a requirement in the Act to have a privacy officer. Every agency has to appoint someone who is a privacy officer. This doesn't mean you have to have every single tiny charity has to have one person whose full-time job is privacy. It could be someone who is doing a bunch of other things potentially, but they do need to know that they are the privacy officer for their organisation, and have some awareness of what their responsibilities are. So they have statutory functions effectively set out here to encourage the organisation to comply with information privacy principles, dealing with requests made to the organisation under the Act, working with OPC during investigations, and ensuring the organisation complies with the provisions of the Act. So for small organisations that don't have a huge amount of personal information, it might be that the general manager or director is the privacy officer. If you're in a slightly bigger organisation, or you already have a risk or legal function, it could sit there. It could be that you're lucky enough to have a staff member who's really, really keen on privacy and just wants to pick it up as part of their job. Lovely. Any comments from you, Lou or Joe, on that one? Easy. All right. So now we come to, I think, the really interesting practical part. So where to start for governance groups who are starting from scratch, basically. So we've got some suggestions of questions that you can ask at your next board meeting. Maybe don't ask them all at first board meeting. Spread them out over, 3 or 4. But they're really good questions, we think, to kind of be a bit reflective in terms of what you know about your own organisation. So what personal information do we hold? From an OPC perspective, knowing your data is really critical to both assessing your privacy risk and also knowing the value of your taonga that you hold, right? And potentially how you can safely innovate with it in a way that is consistent with the Privacy Act. Who is the organisation's privacy officer? So that's coming back to that slide we've just talked about, and whether your staff and volunteers know about them. And as I said, particularly for organisations that might have volunteers spread throughout the country who don't have a huge amount of contact with the staff, or knowing who your privacy officer is really important, making sure that's communicated. So another question to ask could be, what's in our privacy policy and when was it last reviewed? And then, do the information handling practices that we have line up with what we're telling people? So that's a really critical thing, because you could put anything you wanted in privacy policy, but if you're not following it, it doesn't mean a whole bunch. Another question might be, what training do our staff or volunteers get on privacy? How frequent is it? Is it role specific? And then a question internally for governance groups in terms of how they're managing your privacy risks. So what kind of reporting do you get? What oversight do you have about privacy as a risk? Are you getting incident reporting of privacy breaches? Another question is, what service providers do we use that process our personal information, and what contracts do we have in place with them? I think that's another really critical part. And do we have a breach management plan, which reflects the conversations we've had earlier? So now I'll throw to Lou and Jo to add other suggestions or make any comments on any of those as well.
I'm happy to go here. I think these are fantastic questions here. And I really want to reiterate your point there that as I guess through our governance responsibilities, it's not only that we know we have a policy and that there's a process in place, we probably have to get ourselves assurance that that policy is being followed. And yes, we can ask for that to be reported to us in the board reports, but many of us do have the opportunity, say, to be around offices, to talk to volunteers, to be in areas as well. And if we are, it's a great opportunity just to observe and see, are 4 people using a laptop and it's only being logged in once in the morning, so you can actually get a real sense of what's happening. So yes, have a statement around what information, understand what information you have, understand that you have some sort of policy that you're taking, that you care for this information well, but also then just double check when you're around the organisation that you're following that, and it'll be kind of obvious. If you can see passwords stuck to, I guess, laptops, I mean, we've probably all been guilty of that at some stage, but if it's that kind of culture and you're dealing with very sensitive information, you are putting the organisation and that information and the people that you serve at more risk. So a lovely opportunity just to have a wander around and look at what's happening in your environment and just get that sense of assurance that what the policy says is what is actually happening in practice.
Lovely. Thanks, Jo. Lou?
Yeah, I wondered if I could just talk really briefly to that second to last point about service providers that are used to process personal information. So one of the things we see a lot is the use of third-party providers. You've got an IT provider or something like that, and so they are doing things with personal information for your organisation off-site. What can happen is that they themselves experience something like a cyber attack, or for some reason their system goes down. So that takes their system offline while they're dealing with it. And then your organisation is no longer able to get access to the personal information that third party is holding. And what that means is that you're now having a privacy breach as well that may well be notifiable as well as the third party provider. We see this quite a lot in a not-for-profit space because there is a real need to rely on external providers rather than having things in-house. And I have worked on examples where that's been a real surprise for the not-for-profit organisation that suddenly they have this notifiable privacy breach. And it really shows the need for some robust contract with those providers so that if it happens, they're keeping you updated. They do have an obligation to let you know what's going on. Otherwise, you're in this position where you've got a compliance duty to the Privacy Commissioner's office, but no real oversight of the information. And I find too that that's something that the OPC will really scrutinise. What was the strength of the contracts that were in place?
Yeah, I think that's a really good point, and something that I think also arises for me in terms of having previously been involved in a charities board, that you are, potentially a volunteer board that turns over potentially relatively frequently, and you won't necessarily know what was done before your time, and it can be quite hard to figure out where to even start. And I think potentially can be easy to assume that everything that was done prior to you being on the board is totally fine and that there's nothing to look at there, and can feel overwhelming to know where to start. So I think that that's a really good point and a tricky thing to do. But contracts renew, there's always opportunities to take a fresh look. Thank you. Lovely. So I think that's probably enough on these questions for board members, but I can see we've had a few questions come in. We also had one come in ahead of time, which was about using, for not-for-profits, using cloud-based tools like Google Workspace or Drive. So particular recommendations on best practice. So I guess I'll kick off from an OPC answer, and then I'll just throw to you, Lou. You kind of touched on this in that your answer just before, but I guess from the OPC side, we probably can't recommend a particular product or service given our regulatory role. But I will note that we have some information on our website from when OPC decided to move to cloud-based servers in terms of the types of things that we considered and the privacy impact assessment that we followed. And I can pop a link to that in the chat as well, so that you can see the release that we did about moving to external servers. I'll throw to you, Lou, and then I'll see if I've got anything else to add once you've given a much better answer than I can give.
No, so I think there's two elements to best practice for not-for-profits using or looking to use cloud-based tools. The first one is due diligence, and I don't think that needs to be really overwhelming or burdensome. It doesn't need to be instructing lawyers for endless contract review, she said, putting herself out of a job. I think the key thing to look at, first of all, is what is the cloud provider going to do with your personal information? And that can involve kind of digging into their own privacy policy. What you're really looking for is, are they going to use the information for their own purposes? Because that changes the nature of them from just processing it on your behalf to actually becoming a controller, for want of a better term. And ideally, you're steering clear of that. So you are using a provider that is only going to process for you. The other thing too is that there's a growing availability of New Zealand-based options, and they are really worth looking into. And the second part of that is you've done your due diligence and you've selected a tool, a cloud-based tool, not being complacent once it's in place. So making sure that you still have proper security practices in place. You're still thinking about what are we collecting and why, what's the purpose there, how long are we retaining it? And just keeping an eye on term updates. I know we all get those emails that say we've updated our terms and no one really wants to read them, but what you can look at is the summary of changes and just being alert to when they give you a sense of what's changed. Actually, hang on a minute, that might change the way they use our information. We might want to assess whether that is still a good tool going forward.
Awesome. Thank you, Lou. To put you on the spot a little bit, Jo, I had a question for you in terms of agencies actually practically managing their service providers, and whether there's an opportunity for kind of sharing of lessons and potentially even sharing of services across community groups where they do have those connections, say within a sector. I guess speaking from my own experience as someone who was previously on a board of a youth service, there was a real willingness to work together with other organisations, recognising that there's this immense need that the charity is trying to fix, right? And, it's not a competitive kind of situation where you're trying to fight off clients. In fact, we normally had more people than we could serve. And so there was a real opportunity for sharing lessons about how to manage some of those really meaty risks and kind of decisions about contracts and that kind of stuff. Is that something that you've seen?
I think it's a really important topic, Eve, and we'll get quite fundamental and philosophical here. Through the contracting regime over the last few years, we've often seen organisations, if that makes, tendering against each other and all sorts of things. So there has been a reluctance to share, perhaps kind of built into some of the practices around funding. But you're absolutely right. It's absolutely critical. Often we are struggling with the same issues. All of us have the same responsibilities under this Act. All of us want to care for the information. But yeah, I'm sure we're all working it out individually in our own spaces. And I'm sure we're all contracting this similar kind of IT providers or CRMs or and not necessarily sharing. But I do think there's some avenues within the sector where we can do that, and some and hopefully some amazing leadership where boards could just go, hey, let's go and ask the organisation how they did it, across the way or in a different region. So I just love to see more of that. I think what does get in the way is that we are volunteers, right? We're all just doing a great job. We're all just trying to, to deal with the issue that's in front of us, not necessarily thinking about the the 10 or 12 ways we could do things more efficiently. There are a number of networks, there are a number of central places that could be created. And obviously, what you have on your website is amazing. You don't need to plug it, Eve. I'll plug it. And these questions I think are fabulous. I just think it's we should just go to our next board meetings and go, okay, team, how are we looking after the information that we hold it? And it doesn't have to be a technical legal, it just has to be a very sense like, what does good look like? Are we doing it and are we following that policy? So yeah, let's all lean into it, right? And if we don't know, to reach out to use your website, use your resources, visit those modules, or ask the organisation just down the road how they managed it. And you're absolutely right. Let's do it.
Thanks, Jo. All right, we've had a few questions come in through the Q&A, so we'll kick off and I'll read them out and then I'll throw to either of you to answer, and I can tack on anything else at the end as well. So the first question is, are you required to delete personal information if asked by the person prior to the conclusion of the event or reason for collecting the information? Do you want to take that one, Lou?
Yeah, sure. So we don't have a right to request deletion in New Zealand, but I think if someone is asking you to delete it, that's probably a really important time to stop and think whether the reason for collection was clearly disclosed to them at the outset, and does that change your ability to use it? So the really important takeaway there, I think, is being upfront at the beginning of something. What are you collecting from someone and why? That can get quite tricky at events, you know, taking photographs or taking recordings, but there are practical ways that you can be transparent with that. And if someone asks you to delete it, no, they don't have an express right to deletion, but really thinking about, does that change your ability to use it?
I think that's a great point, and also what does it mean for your reputation in terms of your relationship with that individual as well, right? Even if it's not a legal right. All right, so the next question is, what about reporting requirements for funders who, which could include narrative or qualitative information about clients or outcomes, although not naming them? I guess I can start that one, and both of you feel free to jump in. So the Privacy Act does include provision for use of disclosure of information where the individuals concerned are not identified. Obviously, that's whether or not the data set that you're being required to provide to your funder has been sufficiently de-identified is a question, depending on the context and the facts and what the actual data looks like that you're providing. But the other thing to think about is whether disclosure of personal information to funders is anticipated by your privacy statement, by what you're telling the people that are interacting with your service, and where you are being really upfront with your clients that you do have, say, a contractual requirement to tell funders about outcomes or share some level of information. If you can put that up front before you collect the information, you don't need to worry so much about the exact extent to which each individual data set is de-identified. It's also a really good transparency element, actually being clear that accountability to your funders is one of the reasons for which you're collecting information in the first place, and that's how you can continue to deliver your services. That's probably my answer for that one. Did either of you want to add to that?
I would just add, as you mentioned right at the beginning of the session, just being careful that not naming an individual isn't necessarily enough. So I know you've mentioned de-identifying, but there's lots of other ways that you can still track back and work out who individuals are. So just being very, very careful that taking names out might not be enough to protect against, breaching the privacy of some individuals that are within your data set.
So the question is a really thoughtful one. We often report in our annual reports using case studies or client stories. And I guess the advice you're giving is that yes, but you have to be very, very careful. Person A who has 3 kids who lives in this place you could track it back if they're a client. So you're saying we can absolutely do this, but just to be very careful about how we do it. The story is important. The outcomes are important. We need some, I guess, hope and great. Often we're telling good stories. So we should not stop doing that, but we just have to be careful,
Exactly. And I think it's also about recognizing where the value is in terms of both. So from a funder's perspective, are they actually what is the reason that they need that level of detail? And having that kind of conversation with them where you can do that is a good way to figure out how you can achieve both, your funder's accountability requirements, as well as protecting the privacy of the people that you're serving. All right, so we've got a question about, would you recommend having a specific email address for confidential information? How best to manage information being sent via email to managerial team? That's quite a specific question. I guess I'd just note that the Privacy Act isn't concerned with this idea of confidential information necessarily, and it doesn't inherently prioritise some information as being more sensitive than others in terms of the regime of the Act. There will be some information that's more sensitive than others depending on the circumstances. So health information, biometric information is likely to be particularly sensitive, but depending on the circumstances, something that might mean nothing to me might be very sensitive for other people. So it's a good idea to be bearing that in mind when you're setting up your systems and processes. It's probably about as specific as I can be on that one, I think. But Lou, did you want to add anything?
Well, I was just going to say, I think having a privacy-specific email address is really good for privacy-related matters that come in from the outside. So like having all your requests for access or correction go to a specific inbox as long as it's monitored. That's a good way to separate that out so that you don't run the risk of missing the 20 working day time frame. But in terms of within your organization, setting a dedicated email address to send personal information back and forth internally isn't really going to do anything to show that you've been any more protective if something goes wrong. It's more about security measures around accessing the information in the first place, checking that you're sending it to the right person, not sending backwards and forwards something. Do you need to make that an attachment, or could you, for example, just refer someone to a file address within your system? So if that's the concern, probably a dedicated email address isn't the most targeted way of improving your privacy processes.
Awesome, thank you. I'm going to throw the next one to you, Jo. So this is, do you have any comments on the burden of compliance generally? At what point does resourcing legislative compliance become such a drain on time and funds that charities become redundant, unable to deliver a service? That's a tricky one.
Yes, and it's a lovely comment from Becky, and I feel like giving her a hug. That's the I do think there is we can look at, say, for example, privacy. We can look at privacy as a compliance exercise that has a regulatory framework around it, or we can also say it's actually about gathering great information about our clients and protecting it and using it well, which is the leadership. It is part of our service. So I guess it is just really how you frame it, and is probably how you approach it. I chair a very small service provider that works with some of the most complex members of our society, and with a sort of in some of the most high risk environments, and I totally understand how compliance feels. But if you see it about as safeguards to you and for you as a board, even it's there to protect us all, and then finding the ways to operate within it. It's just actually part of good leadership. So my challenge to Becky is to see it as part of good service delivery, is about part of being awesome and making a huge impact. And then to find ways like resources like you've got to make it easy. There are a large number of hubs for the not-for-profits that have a huge amount of free resources. And of course, just to ask and to share how others have done it as well. And I think that kind of makes it, I guess, easier. Though acknowledging it can be daunting, acknowledging that, when you start to see acts and compliance and laws and stuff, it all just seems a long way away from what you're actually trying to do. I would just say, can you reframe it to see it as part of just being awesome?
Awesome, thank you. Lovely. We've got a question that's come in about, does OPC provide contract examples with IT providers? As a charity paying for lawyers to write contracts is not always financially possible. Totally recognise that. That's a really pragmatic thing. I can say we are working on some guidance at the moment about things to consider when you are using service providers, and the particular section in the Act that relates to this. So it's Section 11 of the Privacy Act, if you want to have a look. And there'll be some really good things to think about the types of things that you might want to be putting in your contract. So hopefully that will be useful. And we also have some model contract clauses for where you're looking at sharing information with overseas agencies as well. That a different context to standard service providers, but there's some ideas for drafting to put comparable privacy safeguards in there as well. Now I know we're going to actually finish up at 10:25 just because there's another webinar starting bang on 10:30. So I'll just cover off another couple of questions. How does it work with not being able to keep personal information when you don't need it anymore, and IT providers backing up data that you delete? Do you want to take that one, Lou?
Yeah, so a few things to think about there. Sometimes how long you need it might be determined by something else. So for example, if it's financial information, you might have an obligation to keep it. I know, for example, personnel files, lawyers have obligations to keep files for a certain period of time. So first of all, the assessment about how long is going to change depending on what it is. The other thing there is to talk with your IT provider about their backups and actually get some transparency about how long they are keeping backups for. Sometimes it might only be for 30 days or something like that. And conversely, that can be quite tricky too if later on you need a backup and actually it wasn't for a very long period of time at all. So I think if you have a provider that's doing backups for you as part of the governance group, knowing how long that, knowing what that service provides in general, including how long backups are kept for and when they're going to be available, is actually a really key part of using their service.
Yeah, that's a great point. Thank you. There's a question here about sharing staff members' details, either for funders or accreditation purposes. There's a couple of questions on that. So I guess I would just note that staff members have privacy too, and where there is an anticipated use of your staff members' information, that it's going to have to be shared. It is a good idea to make sure that your employment policies are really clear about that, and that they know that that's part and parcel of doing their job. So that's probably all I'll say on those ones. And then we've had a question about volunteering with children and on a committee. Lots to think about here. If we do some work, is there someone that can check our policy or work to comply? From the OPC side, you can email us either inquiries@privacy.org.nz or guidance@privacy.org.nz. I can't promise that we'll have time to review everything, given we're a fairly small office that regulates a very broad sector, but we will consider requests for specific advice, so you can get in touch with us. And obviously there is a market of excellent privacy professionals such as Lou and other privacy consultants who can support as well. I think we'll leave it there because we're running out of time. I'd just like to thank you so much, Joe and Lou. This has been absolutely awesome. Really great to get that on the ground practical examples from both of you. So thank you so much for your time, and thanks everyone for attending as well. All right, kia pai tōra. Thanks. Bye.